Good evening and welcome to the third week of the current criminal law series. The beginning of the series, we mentioned that the consistent criticism had been that we had attempted to make humorous introductions unsuccessfully, and we're told to just provide factual introductions, and we had done that in the first week and second week. Today, we're going to go one step further. Unfortunately, Michael has the CVs and the background material on our three guests tonight. I don't have any material on them. As a result, although I think we all know the courts from which they come, aside from merely introducing them in terms of their name, there'll be no introductions whatsoever tonight. Our first speaker tonight, the Honorable Mr. Justice O'Leary.
The defenses of insanity and automatism are both based on the common law principle that if a man is not responsible for his actions and engages in what would otherwise have been criminal conduct, he is entitled to be acquitted. Thus, a man is not to be held responsible for acts performed by him while he is unconscious or semi-conscious, or while by reason of disease of the mind or defect of reason he is unable to appreciate the nature and quality of an act, or that its commission is wrong. Automatism means unconscious, involuntary action, the state of a person who, though capable of action, is not conscious of what he is doing. Automatism may be caused by a disease of the mind, in which case it constitutes insanity for the purposes of our criminal law. Or automatism may be caused by something other than a disease of the mind, in which case it is non-insane automatism. Although the defense of insanity was recognized by the common law not later than the 14th century, the defense is still evolving. The defense of insanity has been codified in Section 16 of the Canadian Criminal Code. The provisions of Section 16 are derived from the McNaughton Rules drawn up in 1843. But as will be discussed later, they contain an important modification. Section 16 provides that no person shall be convicted of an offense in respect of any act or omission on his part while he is insane. The section further states that a person is insane when he is in a state of natural imbecility or has a disease of the mind to the extent that it renders him incapable of appreciating the nature and quality of an act or of knowing that it is wrong. In regard to the defense of insanity, apart from natural imbecility, the threshold question is, did the accused at the relevant time suffer from disease of the mind? The term disease of the mind performs an exclusionary function and serves to exclude from the defense of insanity the person who is only duly excitable, simply stupid, in a blind rage, or intoxicated as the result of the consumption of drugs or alcohol. None of these conditions constitutes a disease of the mind. If a person is suffering from disease of the mind, it is irrelevant that it was caused by his self-induced intoxication. With the emergence of the defense of automatism, the problem of judicially defining disease of the mind became acute in order to distinguish between insane and non-insane automatism. The first observation to be made about the term disease of the mind is that it is a legal term, not a medical work of art. There is no psychiatric condition called a disease of the mind. Since disease of the mind is a legal term, the determination of its meaning is a question of law for the judge in a criminal trial. It is for the judge to decide what mental states are comprehended by the term disease of the mind. That term contains both a legal or policy component and a medical component. The legal or policy component relates to the scope of the exemption from criminal responsibility to be afforded by mental disorder or disturbance, and to the protection of the public by control and treatment of those who have caused serious harm while in a mentally disordered or disturbed state. Society has a legitimate interest in persons who have committed serious social harms, but who are found not to be criminally responsible on account of mental disorder. It is justified in submitting these persons to further diagnosis and assessment, exercising appropriate control over them if necessary, and providing them with suitable medical treatment. The medical component of the concept disease of the mind is the medical evidence as to how the mental condition of the accused is characterized from a medical point of view, that is to say, whether the accused is suffering from any mental disorder, and if so, its seriousness, symptoms, and causes. As was stated by Mr. Justice Martin in Regina versus Raby, a 1977 decision, in strictness, a medical witness is not entitled to state that a particular condition is or is not a disease of the mind, since this is a legal question. In practice, however, it is often convenient and permissible in the discretion of the judge for a medical witness to testify in those terms. It is then for the trial judge to decide whether the mental condition described by the medical and other witnesses could constitute a disease of the mind. It is for the jury, for the cases being tried by a jury, to decide whether in fact the accused was suffering from a disease of the mind when he committed the act. The term disease of the mind includes not only mental disorders which have an organic or physical cause, but also comprehends purely functional disorders with no discernible physical cause. The mental disorder may be permanent or temporary, curable or incurable, recurring or non-recurring. On the other hand, transient mental states or disturbances produced by concussion, drugs, or somnambulism do not constitute disease of the mind. The most recent attempt to formulate a test for disease of the mind is to be found in the Ontario decisions of Regina versus Raby and Regina versus Simpson, both 1977 Court of Appeal decisions. In Regina versus Simpson, the Court of Appeal dealt with the controversy over whether the personality disorders, also known as character disorders and psychopathic personality, can constitute a disease of the mind. That group of disorders are characterized by the antisocial personality, the basically unsocial individual, incapable of significant loyalty to individuals, groups, or social values, grossly selfish, callous, irresponsible, impulsive, and unable to feel guilt or learn from experience and punishment. Mr. Justice Martin stated, "In my view, it has been implicitly recognized by both the Supreme Court of Canada and the House of Lords that the personality disorders or psychopathic personality are capable of constituting a disease of the mind. Obviously, mental disorders comprehended by the term disease of the mind are not confined to those mental disorders that were recognized as such at the time McNaughton's case was decided. The concept disease of the mind is capable of evolving with the advance of medical knowledge." In Regina and Raby, the court was presented with the problem of distinguishing insane and non-insane automatism. Mr. Justice Martin stated, "Automatism caused by disease of the mind is subsumed under the defense of insanity, leading to the special verdict of not guilty on account of insanity, whereas automatism not resulting from disease of the mind leads to an absolute acquittal, unless induced by voluntary intoxication due to the consumption of alcohol or drugs, or unless foreseeability or foresight with respect to its occurrence supplies the necessary element of fault or mens rea, where negligence or recklessness constitutes a basis of liability." In Regina and Raby, the accused relied on a psychological blow as a foundation for non-insane automatism. The defense evidence was that a psychological blow of rejection by the victim, a girl of whom the accused was very fond, put the accused in a dissociated state, during which he attacked the victim. The issue then was whether this dissociated state was a disease of the mind. The majority of the Supreme Court of Canada agreed with Mr. Justice Martin and adopted his reasons as follows. In general, the distinction to be drawn is between a malfunctioning of the mind arising from some cause that is primarily internal to the accused, having its source in his psychological or emotional makeup, or in some organic pathology, as opposed to malfunctioning of the mind, which is the transient effect produced by some specific external factor, such as, for example, concussion. Any malfunctioning of the mind or mental disorder having its source primarily in some subjective condition or weakness internal to the accused may be a disease of the mind if it prevents the accused from knowing what he is doing. But transient disturbances of consciousness due to certain specific external factors do not fall within the concept disease of the mind. In my view, the ordinary stresses and disappointments of life, which are the common lot of mankind, do not constitute an external cause constituting an explanation for a malfunctioning of the mind, which takes it out of the category of a disease of the mind. To hold otherwise would deprive the concept of an external factor of any real meaning. In my view, the emotional stress suffered by the respondent as a result of his disappointment with respect to Miss X cannot be said to be an external factor producing the automatism within the authorities, and the dissociative state must be considered as having its source primarily in the respondent's psychological or emotional makeup. I leave aside, until it becomes necessary to decide them, cases where a dissociative state has resulted from emotional shock without physical injury, for example, as being involved in a serious accident, being the victim of a murderous attack with an uplifted knife, or seeing a loved one murdered or seriously assaulted. Such extraordinary external events might reasonably be presumed to affect the average normal person without reference to the subjective makeup of the person exposed to such experience. Indeed, the courts have for many years been giving an ever wider meaning to the term disease of the mind. Mr. Justice Ritchie, in 1966, in Regina versus O'Brien, speaking for the New Brunswick Court of Appeals, said, applying a fair, large, and liberal construction to Section 16, I am clearly of the opinion the expression disease of the mind, as used therein, must be interpreted to include a disease of the brain which has affected the mind, even though such effect is of only a temporary duration. In such cases, reason for the time being has been dethroned by disease. Psychomotor epilepsy is, in my opinion, a disease of the mind. In Cooper versus the Queen in 1988, a 1980 decision of the Supreme Court of Canada, Mr. Justice Dixon stated, I share the view of Mr. Justice Dubbin that there is no reason to give a narrow or limited interpretation to the term disease of the mind. In summary, one might say that in a legal sense, disease of the mind embraces any illness, disorder, or abnormal condition which impairs the human mind and its functioning, excluding, however, self-induced states caused by alcohol or drugs, as well as transitory mental states such as concussion. In Cooper versus the Queen, the trial judge had virtually withdrawn the defense of insanity from the jury because of a psychiatrist's opinion that certain conditions suffered by the accused were not diseases of the mind. The Supreme Court confirmed that the term disease of the mind is not purely a matter of psychiatric definition. Usually, however, the question of whether the accused is suffering from a disease of the mind is not the crucial question where the defense of insanity is advanced. Normally, when a defense of insanity is raised, there is a general agreement that the accused is suffering from some medically recognized mental disorder or mental illness. The crucial question is whether the mental illness or mental disorder rendered the accused incapable of appreciating the nature and quality of the act or of knowing that it was wrong. Nevertheless, if the precondition that the accused at the time of the act was not suffering from a disease of the mind, then if that has not been met, then apart from a condition of natural imbecility, the defense of insanity is not available. In Regina versus Simpson, Mr. Justice Martin dealt with the meaning of the words incapable of appreciating the nature and quality of an act. He stated, "The 1956 report of the Royal Commission on the Law of Insanity emphasized that the word appreciate in the first branch of Section 16 is not synonymous with the word know, which is found in the MacNaughton Rules. The report states, under the Canadian statute, a disease of the mind that renders the accused incapable of an appreciation of the nature and quality of the act must necessarily involve more than the mere knowledge that the act is being committed. There must be an appreciation of the factors involved in the mental capacity to measure and foresee the consequences of the violent conduct." Mr. Justice Martin referred with approval to the charge to the jury of Chief Justice McClure in 1959 in R versus O, in which he instructed the jury that the accused should be found not guilty on account of insanity if they found in a mere preponderance of probability based on the evidence taken as a whole that the accused was laboring under disease of the mind to such an extent as to render her incapable of foreseeing and measuring the consequences of her act, or of estimating a right or perceiving the full force of her act. In other words, the true test is not did the person know what he was doing. The test is, at the moment of the offense, was the accused, by reason of disease of the mind, deprived of the mental capacity to foresee and measure the consequences of the act. However, in Regina versus Simpson, the psychiatric evidence was not that the accused was incapable of understanding or realizing what he was doing, but rather that he lacked normal emotions and was therefore incapable of experiencing normal feelings concerning the acts. Justice Martin concluded that on this evidence the accused was not insane. He said, "While I'm of the view that Section 16 exempts from liability an accused who, by reason of disease of the mind, has no real understanding or of the nature, character, and consequences of the act, I do not think the exemption provided by the section extends to one who has the necessary understanding of the nature, character, and consequences of the act, but merely lacks appropriate feelings for the victim, or lacks feelings of remorse or guilt." For what he has done, even though such lack of feelings stem from a disease of the mind. Appreciation of the nature and quality of the act does not import a requirement that the act be accompanied by appropriate feelings about the effect of the act on other people. The Supreme Court of Canada in Cooper has considered the distinction, and Justice Dixon, speaking for the court, stated, "To know the nature and quality of an act may mean merely to be aware of the physical act, while to appreciate may involve estimation and understanding of the consequences of that act. In the case of the appellant, as an example, in using his hands to choke the deceased, he may well have known the nature and quality of the physical act of choking. It is entirely different to suggest that in performing the physical act of choking, he was able to appreciate its nature and quality in the sense of being aware that it could lead to or result in her death. In the opinion of the medical expert who testified at the trial, the appellant could have been capable of intending bodily harm and of choking the girl, but not of having intended her death." A recent illustration of how failure to appreciate the consequences of an act can satisfy the requirement of Section 16 is to be found in Regina versus Abbey, a 1981 decision of the British Columbia Court of Appeal. In that case, the accused was charged with importing cocaine and possessing cocaine for the purpose of trafficking. The accused had the capacity to appreciate the nature of the act of importing and of possessing the cocaine, and the capacity to appreciate the immediate consequences of those acts. That is to say, that they were illegal, that he should not commit them overtly, and that if he succeeded, he must then deliver some of the cocaine to his friends who gave him the money for it, and find someone through another friend who would buy the rest at a large profit to himself. He was, however, suffering from a disease of the mind, mania, which caused him to have the delusion that he was protected by some mysterious external force from punishment for his illegal conduct. The trial judge concluded that because of that delusion, the accused had his ability to appreciate the nature and quality of his act incapacitated to the degree required to meet the test. He is, by disease of the mind, deprived of the ability to assess an important consequence of his act. He is deprived of the effect of the penal sanctions in restraining the commission of a crime, as it should restrain us all. This man knew it was a crime, knew there was a penalty, but by delusion believed himself protected. On appeal by the Crown, the British Columbia Court of Appeal concluded in the words of Mr. Justice Taggart, "The Crown has failed to show that the judge erred in holding that the respondent suffered from a disease of the mind, and that the delusion that he was protected from punishment by some mysterious external force incapacitated him from appreciating the nature and quality of his acts." The argument in Canada over the meaning of wrong in Section 16 of the Code, whether it means legally wrong or morally wrong, has now been settled by the Supreme Court of Canada in Swartz versus the Queen, a 1976 decision, where Mr. Justice Martland for the majority held that wrong is to be interpreted in the sense of illegal. Who may raise the defense of insanity? In some cases, to permit the Crown to introduce evidence of insanity might prejudice the legitimate interests of the accused and unfairly undermine his chance of obtaining an unqualified acquittal, where his defense is a denial of his doing of the act or an absence of criminal intent. Manifestly, the prosecution cannot be permitted to bolster a weak case that the accused did the act by weak evidence of insanity, which may persuade the jury that the accused is the sort of a person who is likely to have committed the crime. On the other hand, the provisions of Section 16 of the Code are imperative in providing that no person shall be convicted of an act or omission on his part while he was insane. A person who is insane lacks the capacity to commit the offense. Neither the interests of society nor that of the accused may be well served by keeping cogent evidence from the court that the accused was insane at the time of the commission of the act. In Regina versus Simpson, the Ontario Court of Appeal held that in an appropriate circumstance, the trial judge had a discretion to permit the Crown to adduce evidence of insanity. The issue as to insanity may then be raised by the trial judge, by the Court of Appeal, and, as we have in the case of Regina versus Gorecki, by the Minister of Justice himself. So far as the refusal by the accused to be examined by a Crown psychiatrist, it is clear that an accused has the absolute right to refuse to submit to a psychiatric examination, and there is no impropriety in defense counsel informing the court that he has so instructed his client. However, the Ontario Court of Appeal held in Regina versus Sweeney, a 1977 decision, that evidence of the accused's refusal to be examined is admissible against him. On the accused's trial for murder, the only defense raised was insanity, and the court held that the accused's refusal to undergo a psychiatric examination by psychiatrists retained by the Crown was a clearly relevant fact from which it could be inferred that the defense of insanity was either contrived or so weak that it could not withstand scrutiny. The consequences of the special verdict. The perhaps unfortunate connotation of the special verdict of acquittal on account of insanity and the lack of alternative dispositions available to the trial judge following such a verdict are no doubt factors contributing to the increasing number of cases in which the courts are confronted with the difficult problem of distinguishing between insane and non-insane automatism. In Regina versus Saxell, a 1981 decision, a provincial court judge refused to order that an accused be kept in strict custody until the pleasure of the lieutenant governor was known, following a finding that the accused was not guilty by reason of insanity, because in his view, such an order would constitute cruel and unusual punishment and would be contrary to the Canadian Bill of Rights. On an appeal by the Crown, Mr. Justice Weatherston, speaking for the Ontario Court of Appeal, said, "The learned trial judge in his reasons and counsel in argument on this appeal spoke of arbitrary detention and indefinite confinement under conditions more harsh than those suffered by an insane person confined under the civil process. There is no evidence before the court to justify the use of those epithets, nor is there evidence that persons continue to be held in custody after they have ceased to be a danger to the public. The legislative scheme established by Parliament is, therefore, that when a judge's order has been made, the Lieutenant Governor is first required to form an opinion whether the present condition of the accused is such that it would be in his best interest and not contrary to the interest of the public for his immediate discharge, either absolutely or conditionally. Then, if he does make an order for the safe custody of the accused, the Advisory Review Board is required to review the case within 6 months and thereafter at least once in every 12-month period, and in addition, when requested to do so by the Lieutenant Governor. Thus, the fate of an accused who has been acquitted on account of insanity is removed from the judicial process and entrusted to the Lieutenant Governor under a code of procedure that ensures review at reasonable intervals by experts in the field of mental health. Does this scheme abrogate, abridge, or infringe on the right to equality before the law? I think not. Moving on now to automatism. Voluntary conduct is essential for criminal liability. If a person's bodily movements are not subject to the control of his will, there is no voluntary conduct. Automatism has now become the term used to denote unconscious, involuntary behavior. Automatism may be produced by a disease of the mind or by some external cause, such as a blow on the head or drugs. As already stated, automatism due to disease of the mind is subsumed under the defense of insanity, leading to the special verdict. On the other hand, automatism produced by concussion or drugs is described as non-insane automatism and constitutes a complete defense. Where, however, automatism is produced by self-induced intoxication due to the voluntary consumption of alcohol or drugs, it gives rise only to the defense of drunkenness. Non-insane automatism, when not produced by the voluntary consumption of alcohol or drugs, is, as mentioned earlier, a complete defense, unless, of course, foresight or foreseeability with respect to its occurrence supplies the necessary element of fault where recklessness or negligence constitute a sufficient basis of liability. Thus, a person who is aware that he is subject to blackout might be criminally negligent in undertaking to drive a car, although he was in a state of automatism when an accident occurred. The problem of distinguishing between insane and non-insane automatism has been described as intractable. In Regina versus Quick, a 1973 decision of the Criminal Court of Appeal in England, it was held that automatism due to hypoglycemia, a condition brought about where there is more insulin in the bloodstream than the amount of sugar there can cope with, was not caused by a disease of the mind, but by the accused use of insulin prescribed by his physician and hence constituted non-insane automatism. Mr. Lord Justice Lawton, delivering the judgment of the court, said, "Our task has been to decide what the law means now by the words disease of the mind. In our judgment, the fundamental concept is of a malfunctioning of the mind caused by disease, a malfunctioning of the mind of transitory effect caused by the application to the body of some external factor, such as violence, drugs, including anesthetics, alcohol, and hypnotic influences, cannot fairly be said to be due to disease." The Court of Appeal for Ontario in Regina versus Raby observed that the external causes listed by Lord Justice Lawton were not necessarily exhaustive, and by way of example pointed out that delirium produced by the toxins of infection would not constitute a disease of the mind. Sleepwalking is not produced by an external factor, but it has consistently been classified as non-insane automatism. As the court in Regina and Raby observed, sleepwalking appears to fall into a separate category. One of the most difficult problems with which the courts have had to deal arises out of the so-called psychological blow cases where automatism is said to have resulted from emotional stress. As has already been discussed, it was decided in Regina versus Raby that a dissociative state caused by a psychological blow is a disease of the mind, except perhaps where the psychological blow was so severe that it might reasonably have so affected the average person exposed to such an experience. The burden of proof when the defense of automatism is raised. While the burden is on the Crown to prove beyond a reasonable doubt that the accused act was voluntary, the Crown may ordinarily rely on the presumption of voluntariness. A substantial body of case law has therefore developed on the question of what evidence is required to make automatism a live issue. In Bratty versus the Attorney General for Northern Ireland, a 1962 decision, the Lord Chancellor stated, "One must not lose sight of the overriding principle laid down by this House in Wilmington's case, that it is for the prosecution to prove every element of the offense charged. One of these elements is the accused's state of mind. Normally, the presumption of mental capacity is sufficient to prove that he acted consciously and voluntarily, and the prosecution need go no further. But if, after considering evidence properly left to them by the judge, the jury are left in a real doubt whether or not the accused acted in a state of automatism, it seems to me that on principle they should acquit, because the necessary mens rea, if indeed the actus reus, has not been proved beyond a reasonable doubt." But in Bratty, Lord Denning added that the evidence of the accused himself would rarely be sufficient to displace the presumption that a man's act is presumed to be voluntary, unless there is evidence from which it can reasonably be inferred that it was involuntary, unless it is supported by medical evidence which points to the cause of the mental incapacity. In Regina versus Berger, a 1975 decision of the British Columbia Court of Appeal, Mr. Justice McIntyre stated, "In applying the defense of automatism, it is clear from the authorities that there is no burden of proof imposed upon the appellant in raising this defense beyond pointing to facts emerging either from his own evidence or that of the Crown which indicate the existence of such a condition. Once this is done, the Crown must discharge its ordinary burden of proving the act of the appellant to have been conscious and voluntary. If on the whole of the evidence the jury is left in doubt on this issue, the accused is then entitled to be acquitted." He went on to say, however, as to the complaint that the trial judge suggested a need for corroboration of the appellant's evidence, I find that complaint is without merit. And he quotes what the trial judge stated to the jury. And the trial judge had said, "Now it would be very easy for any person accused of a crime to simply say, 'I was unconscious, my act was involuntary,' and thereby raise a doubt in the minds of the jury and be acquitted of that criminal charge. To guard against such an event, there must at least be other evidence supporting the contention that the act of the accused was wholly involuntary." In regard to those comments by the trial judge, Mr. Justice McIntyre said, "This, in my view, was an unobjectionable statement. The need for more than the mere word of the appellant to form a basis for this defense rests not only in common sense, but has judicial support." Conversely, automatism will rarely be viable in the absence of the accused's evidence. However, where the defense is based on a blow to the head, the accused need not give evidence in order to permit the defense to be put to the jury. The defense may be based upon evidence of other witnesses as to the blow and resulting bruises, as well as expert evidence as to the unconscious state resulting from a concussion. As already stated, a proper foundation for the defense of automatism must appear in the evidence. The mere assertion by the accused that I had a blackout will provide no such foundation.